Jeremy, is that you with the music?
Yeah, I just shut it off.
Okay, thanks.
So we're just waiting.
Yep, right now. He's here now.
Good morning.
Good morning, Your Honor.
Morning.
Court is now in session. Jeremy Moore versus Amanda Moore.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff Jeremy Moore. Mr. Moore is present. In addition, Attorney Alex Goldman has filed an appearance on behalf of representing the defendant Amanda Moore, and Ms. Moore is present. The court knows it's a relatively short-term marriage. Ms. Hills, Mr. Goldman.
Yes, Your Honor. I believe we've both spoken with our clients, and at this time, I believe they're both in agreement that the case should be dismissed without prejudice, so that they can pursue the possibility of reconciliation. And I have made my client aware, I'm sure Mr. Goldman has as well, that if in the unfortunate event things don't work out, that if they do have an agreement, we could bring the case back on a motion to reinstate. But it is my understanding that they wish to dismiss without prejudice at this point.
Wonderful, wonderful. And yes, the court would open the case upon find of a motion, assuming provided that there was a resolution, Ms. Hills and Mr. Goldman. All right, do you wish to voir dire your clients, Ms. Hills?
Just very briefly, Your Honor, if I could.
Please.
Mr. Moore, you've heard what I just put on the record as far as a dismissal?
Yes.
And you understand the without prejudice part means that it could be brought back on a motion if in fact things don't work out, and you and Amanda reach an agreement in the future on what a divorce judgment would look like?
Yes.
All right, and that's what you're asking happened today?
Yes.
All right, do you have any questions for me?
No, not at this time. I think
Right.
you explained everything pretty good yesterday.
All right. Were you satisfied with my services during the case?
Yes.
Thank you. I don't have any further questions.
Thank you, Ms. Hills. Mr. Goldman, do you have any questions for Ms. Moore?
Briefly, Your Honor. Thank you. Amanda, did you hear the questions that Ms. Hills asked Mr. Moore?
Yes, I did.
And do you agree that you would like to proceed this way?
Yes.
Nothing further, Your Honor.
All right, thank you, Mr. Goldman. It's wonderful news, Mr. and Mrs. Moore, and the court certainly wishes both of you the best. And it's definitely worth attempting to explore reconciliation, even if you need the assistance of a counselor. So I wish you the best in that regard. Ms. Hills, will you prepare then? We need to stipulate order of dismissal. Will you prepare such a written document?
It is underway, Your Honor. Yes.
Okay. All right. Anything further?
Not today.
If
And
not,
hopefully
thank you all
not.
for
Hopefully not
appearing.
ever.
Yep, absolutely. Well, good luck to both of you, Mr. and Mrs. Moore. And that will conclude this matter. You can all zoom out. Have a good rest of the day and weekend.
Thank you, Your Honor.
Thank you, Your Honor.
Before the court for
Thank you.
pretrial
Have a great
conference,
day.
the same is being conducted via Zoom. Is Brian Dward present
Yeah,
on audio? Good morning.
good morning.
Also present is Attorney Stephen Rotenberg, representing the plaintiff Krista Collins. Is Ms. Collins, are you present as well?
I'm present.
Judge, she's a
Good morning.
defendant. There's a DS case, and she originally filed for divorce, but Mr. Durard beat us to the clerk. So for clarification, she's a defendant, counter plaintiff.
Okay, yes, that's noted. Brian is a plaintiff. Crystal is the defendant, counter plaintiff.
Yes. And Mr. Durard has not answered the counter complaint, so we would ask that he be defaulted.
Well, Mr. Gerard has appeared. Mr. Gerard, obviously, he should technically file an answer to the counter complaint for divorce, but yeah, he can still proceed on his complaint, Mr. Brownberg. So the main thing is that he's appeared this morning. Mr. Gerard, your address is still 16?
Correct.
All right. Okay, we have about what 4-year marriage here? Is that correct? How long have the parties been separated?
Judge, it's a 20-year marriage. It was common law out of Alabama, I believe. Alabama made common law illegal in the past few years, but because it pre-existed, we have that, and we also have full faith and credit. So it's not a 4-year marriage; it's a 20-year marriage. They filed joint tax returns for 20-ish years, held each other out as husband and wife, etc. So we have that issue there. There's a support issue, there's a custody issue, parenting time, non-payment of child support, and on and on and on. There's a lot of stuff here.
Okay.
And I know Mr. Durard has spoken to at least Leah Rurka, but I don't think he hired her. So this is one hand clapping here.
Right, so this is sort of unusual, Mr. Roberg. So you're suggesting the parties got married in Alabama, and at that time common law marriages were legal?
Yes, they are, and I'm prepared to give. I don't have it right in front of me, but I'm prepared to give you a memoranda if you need it.
And subsequently, the state of Alabama made common law marriages illegal. Is that correct?
Somewhat like they did in Michigan, I think in about 1958 or 59, when they banned it in Michigan, that they wanted to avoid issues of fraud, but all the people who were as best I understand, anybody who was held out as being married prior to that, they weren't going to go ahead and divorce them statutorily.
Is there a case law that indicates it's a valid marriage?
Yes, I'd have. Sorry, Judge, I'm not prepared to answer that question right,
All right.
this instant,
Okay.
but I can answer.
I'm just inquiring. It's the first time
Yes.
this court has encountered that issue. And then the parties remarried in Michigan in December 2019. Is that correct?
Correct.
Yeah, yes, it is, Judge. But again, if you're already married, the act of having an officiant and doing it would be as if, somebody decided to remarry it there at some significant anniversary. It's
Okay.
sort of it's a nullity in the sense that they were already married.
All right. And the only thing relevance the duration would have is in terms of spousal support. Is Ms. Collins requesting spousal support, Mr. Rosenberg?
Yes, she is.
All right. All right. Is there real property at issue?
Yes, there is.
Okay.
There's
How
a
long have the parties
trailer.
been separated?
You'd have to answer that.
2 years. 2 years.
2 years?
Yep, 2 years this month.
Okay, so you were separated in February of 2022.
Correct.
Mr. Gerard, I'm simply completing a pretrial statement. I'm trying to identify the issues. I'll mail you a copy of this. Obviously, yes, I don't know what your position is in the marriage, but if it's a 20-year marriage, then spousal support is an issue. If it's a 4-year marriage, then it's not. But you may want to consult an attorney, even if you don't hire the attorney. But I will send you a copy of this pretrial statement, just identifying the issues. Is there a significant unsecured debt, Mr. Rosenberg?
There's a mortgage. There's a mortgage on the
Unsecured debt.
Secured. I don't believe so.
Unsecured. Mr. Rosenberg, is there a significant unsecured debt?
I do not believe so.
Thank you. Personal property division, is that they've been separated 2 years? Is there some personal property that needs to be divided?
He has a car, but she has no use of a car because she's legally blind.
Okay. So the primary issues are real property division. Who's living in the marital home?
My Crystal is along with the kids, but we have a problem here, Judge, and we're going to have a motion come. I'm going to be filing a motion for this pretty soon. Mr. Durard has been starving my client for cash, and she's going to lose that trailer because the mortgage has not been paid. And she has been, she's on.
Oh, sorry, you made reference to a trailer.
Yeah, it's a mobile home. It's a,
Hold on. I asked if there was real estate. You said yes, there was real estate.
Well, I don't know what to call a mobile home, Judge. You pay a mortgage
It's a
on it.
personal property. There's a title to it.
It's titled to both of them.
It's not real estate. Okay, I'm just trying to understand the issues, Mr. Rosenberg. So there is no real estate, correct?
Correct. I believe that would be correct.
Okay. There are personal property division, and the one that made on its personal property is a mobile home.
Mm-hmm.
Okay, is that is it titled and mortgage in both names?
Correct.
Yes.
All right. Well, Mr. Gerard, that's going to adversely affect your credit if you don't assist in keeping those payments current, especially if your children are living there. So they're the right thing to do.
Well, I have spoke to the mortgage company, and I have the arrangements. I have receipts where I have paid and sent it directly to them.
Is the debt current?
No,
When I talked to them last month, they said it was correct.
no, it's
There's no
not.
proof of that, and I believe that it's approaching a foreclosure situation.
Right, you may want to make further inquiry about that, Mr. Gerard, because that's an issue.
Yeah.
So, okay,
I-
so I'm going to simply note that I'll leave discovery open. Identifying issues, custody, parenting time, spousal support, personal property division,
Attorney's
retirement
fees,
benefits. Do we have retirement benefits, Mr. Olberg, need to be addressed?
the what benefit? Hold on, I didn't catch what you said.
Retirement benefits.
I don't know if he has any.
No,
Mr.
My
Gerard, do you have any,
client, I don't believe does.
pension? Mr. Gerard, do you have any pensions or retirement plans?
no.
All right. All right, of course, if we don't find that, first, to be optimistic in case settlement is possible and likely. There's no need for real estate appraisal because there is no real estate. Mr. Rosenberg, you talked with Mr. Walker from the front of the court, and Mr. Walker is giving you a mediation date. Is that correct?
Yes, April 3rd. Another thing too, Judge, and this is another issue that's going to come up, is I know because of my client's disability, she has difficulty finding work in the area, and she likes working. So there's a pretty good chance that she's going to want to or need to move and possibly violate the 100-mile rule. And I just want the court to know that.
Well, she'll need to petition the court.
Yeah, I know, but I just
discussed
wanted to give everybody a heads up.
Maybe that can be discussed at mediation. What time is the mediation? April 3rd, Mr. Rosenberg?
1:30.
Right. All right. So again, Mr. Gerard, the court would suggest you at least consult an attorney, even though you don't hire an attorney, consult an attorney to assist you in this. You are ordered, Mr. Gerard, and both of you are ordered to appear with Mr. Walker to mediate on April 3rd at 1:30 p.m. and subsequently appear before this court for a pretrial conference. The court will provide you with Mr. Walker's Zoom ID number. It will be a Zoom mediation. Mr. Walker is a trained certified mediator that will assist two of you in trying to find some middle ground. I will assure you the best resolution of any divorce action is one in which you both participate, rather than this court decide these matters. Obviously, if Miss Collins is contemplating moving, and I guess maybe the two of you should talk, and maybe Mr. Gerard, you take over the mobile payments, bring it current, or the two of you, if you don't want it, then the two of you should talk about trying to sell it. But it's a tough market to sell manufactured homes. They usually decline in value rather than appreciate in value. So that's something the two of you should talk about.
I want to sell it.
Okay. Well, the two of you, that's something you should talk about. And keep in contact with Mr. Rosenberg, Miss Collins.
Yeah.
Mr. Gerard, do you have any questions for the court?
No, not at all.
All right.
Judge, I'd like the court to also note that Mr. Durard does not wish to give me his phone number, so it's kind of hard for me to contact.
Mr. George, do you have like an email address? And Mr. Rosenberg, let's say there's a proposal. Ms. Collins wants to, and if she wants to go through Mr. Rosenberg, she can do that. Is there some way that Mr. Rosenberg can contact you by maybe email?
So like I said, I told Mr. Walker I would stop in person in just a little while and give him my number.
I'm sorry, the language sort of garbled. You don't have a good device. What did you say about Mr. Walker?
I said, I told Mr. Walker that I would stop in person and give my information.
Well, I need the information, not just Mr. Walker.
And
Mr.
then
Walker is not going to
to
reach out to you. He's not going to, there's no need for him to reach out to you, Mr. Gerard. It's just as simply, if in fact Ms. Collins has a proposal. I mean, it'd be nice if Ms. Rosenberg could forward that proposal to you between now and April 3rd for you to consider. Is there a way that Mr. Rosenberg can communicate with you? That's just a simple question.
Yes.
Okay. How do you want him to communicate? Do you calling you on the phone, or do you want an email address?
An email.
Okay. What's your email address?
Gerard. Correct.
Okay.
All right. And obviously, Mr. Gerard, you're not prohibited from communicating directly with the Crystal. But if in fact, the two of you can't talk, then at least Mr. Roberg can reach out and communicate with you. If in fact, Ms. Collins has indicated she wants to sell the home, if that's something you should talk about, why don't you cut your losses? Either you move in there, take over the payments, or you try to market it.
We'd have to go back to the park.
Yeah, apparently, we'll deal, that's not, Crystal, that's not the time to deal with it. But apparently they can't, the way it's set up, Judge, they have to talk to the mobile home park first and might not be able to sell it on the open market.
Right.
Okay. I'm sure the park has to approve the new purchasers, the new tenants.
I think it gets sold to the park. It looks to me like a sucker deal that unfortunately these people got involved in.
Okay. Perhaps you can look at that lease, Mr. Roberg, and assist them in that regard.
I'm willing to assist my client. I'm not particularly interested
Absolutely.
in Brian, unless he pays her.
Absolutely. But again, obviously, to the extent that you could look at the lease and find out whether or not what there is.
Oh, that I would be willing. That I would be willing to do, but I do not work for Mr.
Right.
It's a month-to-month lease because he would not sign it to renew it.
All right. Anything further, Mr. Roberg?
That's it for today, Judge.
All right. Thank you, Mr. Gerard. Do you have any other anything else? Do you have any questions for the court?
No.
Okay, Mr. Gerard, you have to appear. If you fail to appear on April 3rd at 1:30 for this mediation, you will be defaulted. So you need to appear for that mediation, and immediately after that mediation, you'll appear before this court for a continuing pretrial conference, and all via Zoom.
Okay.
Okay.
All right. All right. Good luck. Thank you, Mr. Roberg. That concludes the pretrial conference. You can Zoom. This matter is before the court for a pretrial conference subsequent to mediation. With Mr. Walker for the front of the court, this hearing is being conducted via Zoom. Present is Attorney Stephen Rodenberg, representing the defendant,
Dependent mother.
I'm sorry, defendant mother, Crystal Collins. I apologize. Defendant mother, Crystal Collins. Ms. Collins is present. Is Brian Gerard present on audio?
Yes.
All right. Good afternoon, Mr. Gerard. Mr. Rodenberg, have the parties made progress toward their own resolution?
Not really. We haven't received any financials from Mr. Durard, other than his complaint that he did, the handwritten complaint. We've got nothing. And he's also been starving my client for cash, so it's difficult for us to do discovery. But we'll talk about that at the motion that's coming up later on after this. So other than a couple minor things involving personal property, nothing has been really resolved. So I'd say the answer is no. And part of the problem we have is that we don't really know what Mr. Durard's finances look like. We have suspicions, strong suspicions that he is underreporting income.
Okay.
On his
Have you submitted
taxes.
interrogatories?
I'm going to send them to him, but at this point, I haven't received anything from him.
Okay. When
He's
were
done.
they due?
I know he contacted Leah Rurka a while ago, but he never hired her.
Understood. When were the interrogatories due? Answers.
I have not sent them. I have not sent them. I have received nothing.
Okay, obviously, we're way too premature in sentence for mediation if we don't have the discovery, Mr. Rodenberg.
Right, but I'm also owed a CC 320 verified statement. I've never seen one.
All right. Have you sent that, obviously, Mr. Gerard is in pro per. Did you send him a copy of that to complete? The reality is it's more work when you got an in pro per party on the other side, Mr. Rodenberg. He doesn't know what these forms are.
Well, I understand that, Judge, but Mr. Durard uses finances to oppress my client, and I am not interested in subsidizing his campaign of oppression.
Right. All right. That's
so
okay,
if he wants to represent himself, he's held under the court rules and the rule, and he's held to the same standard as an attorney. So if he doesn't know what he's doing,
Mr. Rodenberg, it's going to cost your client more time and expense. That's the reality. I'm trying to be very practical. Most attorneys, in 90% of cases, will send the other side to copy the form saying, send us back, and the court will order them to do so. But if you want to make them, we can make
he doesn't have a phone number I can reach him at.
You got an address? Mr.
We don't even
Gerard,
have
what's
a
your
real
current mailing
official
address?
address.
Are you gonna
He unofficially
represent
lives,
yourself?
he
Hold on.
unofficially lives
Hold
with
on.
in his
Hold on,
late
Mr.
mother's
Olberg, hold
trailer.
on. Mr. Gerard, what's your mailing address?
Right. 16, and I did receive the papers he just sent to me. Just the newest one.
I'm sorry, what paper did you receive?
It's a tax form about the change of today's date, the time, 3 o'clock, or
I have no idea
don't
what you're
believe
talking
I
about,
sent
sir. No idea what you're talking about. Mr. Gerard, are you
Yeah,
gonna
it-
represent yourself in this divorce action?
it came directly from him.
Mr.
And
a
Gerard,
big
are you
white
gonna
envelope.
represent yourself in this divorce action? Mr. Drouillard, are you gonna represent yourself in this divorce action for the third time?
Yes. Yes.
Okay, you need to know what you're doing. You have to complete a verified financial affidavit and send that to Mr. Rodenberg, setting forth your employment, your income, your assets. And Mrs. Collins has to also send you a copy. Mr. Rodenberg, have you provided Mr. Gerard with your client's copy of that verified financial information?
Yes, Judge.
Okay. Have you received that, Mr. Gerard?
Just the 2022 tax form papers.
I'm sorry, the 22 what?
2022 tax papers.
That was in the,
That's
that
all I-
was part of the package.
Okay, did you receive a document verified financial affidavit?
Yes.
Okay, you need to provide a copy of that to Mr. Rodenberg.
Okay.
And Mr. Rodenberg can send some interrogatories. You have to answer under oath and have them notarized and returned within 21 days. You understand that? And if you don't do that, you could be assessed attorney fees.
Yes.
If you're going to represent yourself, you need to know what you're doing. Otherwise, hire an attorney. All right. What the court's going to propose, Mr. Gerard and Mr. Rodenberg, the court can take some proofs. The court can establish jurisdiction. There's a breakdown, no chance for reconciliation. The court will reserve outstanding issues. That'll give the court more time to allow parties to complete discovery. Any objection, Mr. Rodenberg?
No, Judge.
Thank you. Mr. Gerard, is it true that you filed the complaint for divorce with this court on about November 8, 2023?
Yes.
Is it further true that on the date you filed the complaint, you resided in the County of Monroe at least 10 days, the state of Michigan at least 6 months?
Yes.
Mr. Drouillard?
Yes.
Is it true that when you filed this complaint, you lived in the County of Monroe at least 10 days and the state of Michigan at least 6 months?
Yes.
Is it further true that you married Crystal Collins on December 13, 2019? You separated in March of 2021?
Yes.
Is it true that there are four children born during the relationship?
Judge, may I
Yes, Mr. Roberg, the court's
apologize.
aware you have, hold on, Mr. Roberg, please don't interrupt. I understand you have allegations that there's a common law marriage in Mississippi. You need to brief that and prove that to the court. The court's gonna treat this as a 4-year marriage, but I'm aware of your position. Mr.
Okay.
Collins, is it true there are Mr. Gerard, is it true that there were 4 children born of this relationship? Mr. Gerard, can you hear the court?
Yes.
Is it true there were 4 children born during this relationship?
Yes.
All right. Ms. Collins, did you hear the testimony of your husband, Brian, this afternoon?
Yes.
Was his testimony true and accurate to the best of your knowledge, with the exception of an alleged common law marriage in Mississippi?
Yeah. Yes.
Are you currently pregnant?
No.
Right, thank you. Mr. Stroberg, do you have any questions of either party?
Yes. Ms. Collins,
Yeah.
when did you start living together with Mr. Gerard?
2000.
Did you ever file taxes as husband and wife?
Every year since 2001.
Have you ever applied for any credit or loans or contracts or even a hotel room saying you were husband and wife?
Multiple.
Have you ever held yourself out in public as husband and wife prior to your formal marriage ceremony in Michigan 4 years ago?
Every day.
to the best of your knowledge, at the time was common law marriage allowed in Mississippi?
Alabama, yeah.
Hold on.
Or
Mr.
else, or
Oldbrook, is she
Alabama, I
qualified to answer
apologize.
that question?
Okay, this goes to her belief, and it also goes somewhat, that would also go somewhat to the length of the marriage, Judge. But I see where you're coming from. Okay, do you believe that, okay, never mind. I'd like to ask Mr. Durard some questions,
Please.
if I may.
Sure, please.
Mr. Durard, did
Yeah.
you start living with your wife in about 2000 or 2001 in Alabama?
Somewhere around there, maybe.
In the early 2000s, did you ever file any tax returns as husband and wife filing jointly?
Yes.
Would it be accurate to say that those tax returns go back to about 2000 or 2001?
I don't recall.
Okay. Would you have ever held yourself out as husband and wife prior to your formal marriage 4 years ago?
Yes.
Have you ever held yourself out in public as husband and wife prior to your
Yes.
formal marriage 4 years ago?
Yes.
Could you give us some examples of times that you've done that?
I don't remember, but I was introduced as wife.
Okay. When did you move to Michigan?
I believe like it was like 2014.
Prior to the divorce, did Crystal work?
Yes.
To the best of your knowledge, is Crystal disabled?
Yes.
What is the nature of her disability, if you know?
She is legally blind.
To the best of your knowledge, do any of your children have any disabilities?
Hunter.
And what's his disability?
They keep saying he needs glasses, so it might be the same thing.
So he might have the same condition as Crystal.
Correct.
Okay. So they're both low vision.
Yep.
Okay. Did they rely on you for transportation to their medical appointments?
Yes.
Did Crystal rely on you for transportation to her job as a picker for Amazon in Ohio?
Yes.
Did Crystal lose her job after you stopped providing transportation?
No, untrue. She actually quit.
Was she able to work after you stopped providing transportation?
Yes, she went to work for Highlight.
Was she able to continue working at her old position at Amazon at the same rate she was working?
No.
So she lost income because she lost transportation?
No.
Are you aware that she'd like to move out of the area so she can better herself and for the best interest of the children?
Yes.
Are you also aware that there's limited facilities and limited resources available for her in Monroe County, or probably within any area in the 100-mile rule?
Yes.
Are you aware that it's likely in the best interest of the children for her to be able to move so she can earn a living and support them?
No.
Are you currently in arrearage with your support obligations?
No.
When was the last time you made a support payment?
Just recently, Friday.
How much did you pay?
I think I paid $230,
How much do
and I've
you
been up to
owe?
date on it. I don't even know.
Are you alleging you're up to date?
I mean, it's behind, but I can't paid all one lump sum.
Isn't it true that you're currently living with a girlfriend?
Nope.
Isn't it true that you're giving this girlfriend and her child expensive gifts?
No.
Isn't it true that you gave this person's girlfriend's child expensive electronics for Christmas?
No.
When was the last time you saw your children?
Christmas.
Was that an overnight?
No.
When was the last time you took an overnight?
I think it was like in November.
What have you been doing in the meantime?
I have been trying to get them. She's got the call blocked. So it goes over a voicemail. I have her Easter baskets at home. And then could I add something? A side note?
Sure.
So she received a check for the working families of $1,655, which was cashed without my signature. And it was cashed on February 26th.
I did notice it up.
Okay,
If it's not, I'll renotice it and I'll redo it. I thought that there was enough, that it was all noticed up and precipitated, etc. If there's an error in that, I'll redo it. It's not a big deal.
well, if Mr. Gerard is willing to address that today, the court was willing to. I do see a motion in the court file. There's a certificate of service that you mailed to Mr. Gerard, the verified financial statement, the 1040 motion, then it says notice of hearing, copy Zoom instruction. I just don't see the notice of hearing in the court file. Mr.
That might
Gerard,
be a shortfall, a deficiency.
let me know when you're done,
on my
Mr.
end.
Robert. Let me know when you're done talking, then I can talk, right? Go ahead,
Right.
keep talking.
I'm not
First of
interrupting you.
all, the court is not aware of any order for support. Is there another case that's open, Mr. Robert? There's nowhere in your response to pleadings or in the complaint for divorce was there any reference to any order for child support? Is there a
Yes,
DS
sir.
case sitting out there somewhere?
Yes, Judge. Yes,
Okay,
that's
can you be
actually
kind enough
what's
to give me
done.
that case?
Yes, hang on one second and I will. Yes.
Thank you. And if in fact, your client can make a complaint with the front of the court if he's in arrears and have the front of the court show cause Mr. Gerard, and in terms of his arrears, thank you. The court was not aware there was a related case out there. Mr. Gerard, do you receive public assistance?
Do what?
Do you receive public assistance?
No.
Okay, but you got a fee waiver. When you filed this divorce complaint, you were given a fee waiver. Let me see what you filed with the clerk. They waived they suspended the filing fee because you alleged that you received Medicaid.
No.
You still receive Medicaid?
No.
He was on my case, Judge, and then they took the worker, when they found out he was not living here, took them off.
All right.
Now, my client does have fee waivers because she is on Medicare and is on SSI and SSD.
It's understood, but the divorce complaint was filed by the plaintiff, Brian. He was given a fee waiver. So obviously the court will address that time of entry, the judgment payment of the filing fee by Mr. Gerard. Mr. Gerard, with whom are you currently employed?
Yes, I'm currently employed.
With whom are you currently employed?
Vent Removal Company.
I'm sorry, Vent?
Yeah, DENT
Okay.
Removal Company.
Okay. Where are they located?
It's 300.
Here in Monroe?
Yes.
Okay. You get paid every week or every 2 weeks?
Week.
What's your take home every week?
It's $400 extra taxes.
I'm sorry, $400 take home every week?
400.
Okay. Mr. Rosenberg is asking for an award of temporary attorney fees so that he can properly represent Ms. Collins. And Ms. Collins needs some financial assistance. Mr. Rosenberg, does your client receive public assistance right now?
On information and belief, yes, Judge.
Okay, what does she receive per week or per month? Is she on
800 and some
Social
odd, hang
Security?
on 1 second. It's 800 and some odd dollars per month. Let me grab the mediation summary because I wrote that down on that. Crystal, you might have to answer that as to how much you make. I know it's 800 and some odd dollars.
Got Social Security
Yeah, she is.
or SSI?
Both.
Yeah, I'm trying to piece together. Ms. Collins, you receive SSI and Social Security, but the total of the two benefits, total $800 a month approximately.
Closer to 900.
The two combined, about $500 a month.
No, the both combined is about 900.
Okay. In addition, you have child support.
When I get it.
Okay, Mr. Roberg, you're requesting an attorney fee of $5,000.
Most of it is to cover expenses, Judge. Court reporters and transcripts are expensive.
Well, first of all, the court suggests do some interrogatories, and then to
Okay.
the extent you need to expand upon that, this should not be a real complicated divorce case. The court suggests send interrogatories, and if Mr. Gerard does not promptly respond to those, you can petition the court for order to compel, and then at which time the court would assess additional attorney fees if necessary. The only assets we have is a marital home and the debt thereon. Is that correct?
No, there's also a car.
Okay.
There's also some tools that Mr. Gerard has because he moonlights mowing people's lawns.
Okay.
So those are, and that's all income that he doesn't report.
Okay.
Because
All
he's
right, so
earning
Mr.
it under
Gerard,
the table.
Mr. Rosenberg is asking for an award of attorney fees today that you would pay to Mr. Rosenberg to assist him in representing your wife. What is your response to that?
I'm unable to.
Well, you've got to, if you do some side work, you've got to do some side work. You've got to do that.
I believe that Mr. Gerard also works for a cleaning company on Ohio.
No, that's untrue. I haven't worked there since I filed taxes.
When did you last file your taxes?
2022.
That's not what your child support paperwork says.
Well, somebody needs to get it right.
You see, this is the problem we have, Judge. We just don't know what he's earning because he's so entrenched in the informal economy.
Okay. So
He's also threatened.
Hopefully,
He's also threatened to not file a tax here.
All right, the court's going to order that Mr. Gerard this time pay $1,000 in attorney fees to Attorney Rosenberg. That without presence, we can address that again at a later point in time, Mr. Rosenberg.
Okay.
Mr. Gerard, when can you pay the $1,000 to Mr. Rosenberg? 3 days?
I can only do payments.
Okay. Court's going to order that be paid on or before May 15th. So, Mr. Rosenberg, you can prepare an order to that effect. Mr. Gerard is ordered to pay $1,000 attorney fees to you on or before May 15th, 2024. Based upon the testimony that's been presented this afternoon, as well as plain files matter, the court finds that jurisdiction has been established and that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, but there's no reasonable chance of reconciliation. At this point in time, the court will reserve all outstanding issues. Schedule this matter for a continued pretrial conference so that discovery can ensue. And with respect to the length of the marriage, Mr. Rosenberg, if your client is seeking spousal support, it's only there's not a lot of assets here. If your client is seeking spousal support, that's only relevance of the length of the marriage. And the court will need a brief in terms of that Mississippi recognizes common law marriage, and that the state of Michigan is obligated to recognize a common law marriage from another state. I'm not aware of any law, but perhaps you can assist the court in that regard.
Clarification, Judge, it's Alabama. And just so you know where it's coming from, it's full faith and credit of the U.S. and Michigan, and for that matter, Alabama constitutions.
If you can brief that issue, that would be appreciated.
Not a problem.
Thank you. So the court's going to set us for another pretrial conference sometime in June. So the court suggested interrogatories to Mr. Gerard. Mr. Gerard, you need to complete that verified financial statement. Get that to Mr. Rosenberg as soon as possible. Presumably that would also request want a copy of your tax returns. Are they filing joint tax returns or separate, Mr. Rosenberg?
Separate at this point. And again, this is hearsay because I'm hearing it through my client who was hearing it through somebody else. On information, Mr. Gerard is not planning on filing his taxes on April 15th. That's what he's saying. I'll see what happens in a couple of weeks, but I'm going to be wanting to see those tax returns and the supporting evidence for it, the schedules, etc.
Okay. Obviously, Mr. Gerard, you don't want to get in trouble with the IRS, so you should not to either request an extension or file that tax return. And once you file, you need to provide a copy of that to Mr. Rosenberg. Again, just make a note to Mr. Rosenberg's in current order, you're going to pay $1,000 in attorney fees on or before May 15th. And we'll send out notice of continued pretrial conference. Are you available on June 21st? That's a Friday, Mr. Rosenberg.
For you, Judge, yes.
Well, give me another day if that's not good for you.
No, it's a good. It's a good day. You are. Yes, we're good.
Okay.
We're good.
10 a.m. Would that work?
Yep. Hang on. Oops. It's crazy on me.
Okay. Is that yes? Okay.
Yes.
Mr. Gerard, I don't know what your work schedule is. The court's going to set another pretrial conference review. That'll be on a Friday, June 21st at 10 in the morning. If you're working, you can step out maybe into your vehicle to Zoom.
Okay. Yep.
It's his uncle's business, so he can leave whenever he wants.
Okay. All right. So the court mail out notice of a continued pretrial conference, June 21st, 10 a.m. Discovery will ensue in the meantime. Mr. Gerard, do make a note to pay $1,000 to Mr. Rosenberg on for May 15th, because otherwise Mr. Rosenberg can file a motion to ask you to be held in contempt. We don't want to hold people in contempt, go to jail for not paying this.
Okay.
And you can still communicate with Mr. Rosenberg. Maybe the two of you can work through your own issues together. This
Okay.
mobile home.
Well, Mr. Gerard, do you have a phone number I can reach you at, or an email that I could reach you at?
I gave it to you last time.
Well, I don't have. That's nice. I would like the phone number. This is just being evasive.
So I did give you the email last time, so.
I'm asking now,
Come on, Mr. Gerard, let's not make things difficult. I mean, obviously, obviously, Miss divorce, correct? So let's try to do this without a lot of, because of the more time and expense that Mr. Rosenberg has to incur, he's going to ask for additional attorney fees. So that's why the court suggested let's get this thing resolved so you can move on with your life.
So it's my last name at gmail.com.
The best way to communicate with you, Mr. Gerard, by Mr. Rosenberg is through email. Is that correct?
Yes.
Do you have a phone number?
Last name.
313.
That's his sister's phone number.
11.
What is it? 8 what?
811. That's his
Miss
sister.
Collins, okay, hold on, Miss Collins. We can't. They've got 3 people talking at one time. Please.
Okay.
Is that phone in your name, Mr. Gerard?
No.
Do you have a phone in your name?
No.
Yes, he does.
All right, we're done. All right.
Okay, thank you, Judge.
Mr. Collins, you seem to know all the answers. Miss Collins, you keep interrupting, so you can get the answers. You can provide that to Mr. Rosenberger. Mr. Rosenberg, you can zoom out, and we'll see everyone on June 21st, 10 a.m.
See you then, Judge.
Okay.
Let the truth stop you, God.
Yes.
Thank you. Please state your name for the record.
Jordan Alexander Freelon.
And Mr. Freeland, if the front of the court does not have your current mailing address, you need to come to the front of the court and change that address in writing. Okay.
Okay.
Right. And Mr. Freeland, do you admit and acknowledge that you are obligated pursuant to order of this court to pay child support for the maintenance of children born to you and Selena Smith?
Yes.
And do you admit and acknowledge you're obtaining arrears in that case about $3,700?
Yes.
You admit and acknowledge you've not made any voluntary payments for some time?
Yeah. Yeah.
You further admit and acknowledge, Mr. Freeland, that you're obligated to pay child support for the children born to you and Caitlin Buckley?
Yeah.
Do you admit and acknowledge in that case you have arrears about $3,900?
Yep. Yes.
Okay, you indicated to the court recently you were working for Tim Hortons. How long have you worked for Tim Hortons?
15 years.
Okay. So in the last 6 months, you have had income from Tim Hortons. You've not paid any of that voluntarily toward front of the court toward your child support obligation. Is that correct?
You said voluntarily?
Correct. I know that Ms. Hicks indicated there was an income withholding order payment received on these cases in January of 2024. But other than it comes out of your paycheck, you made no attempts to voluntarily pay child support to reduce these arrears. Is that correct?
Correct.
And there were some months where there was nothing paid toward your child support. Is that correct?
Correct. Correct.
Ms. Hicks, just for the record, were there a number of, prior to the January 2024 income withholding order payment, had you received any payments on these cases from Mr. Freeland or your income withholding?
Your Honor, we received payments through income withholding in the months of November, December, and January. Prior to that, we had not received any money since July of 2023. And then prior to that, it was March of 2023.
Okay,
and
thank
prior
you.
to that, there's long periods in between.
Okay, so Mr. Freeland, between July and November of 2023, you were working for Tim Hortons. You did not pay any child support. Is that correct?
I don't think I was working at that time. I think I might have been like on.
Hold on.
I think I got injured.
Excuse me. You worked for Tim Hortons for 15 years.
I do, but listen, I just said I might have got injured around that time. Like I might have had a medical leave around that time. So like I think it was around that time because I think I was getting ready for the Olympics, and I had injured myself when I was sparring, and I had a real bad injury on my arm or whatever. I think I had to stop work or whatever. I think what month you said it was like around like March, July-ish. It was around that time.
Between July and November, the front of the court received no payments.
Yeah, it might have been around that time. Yeah.
All right. And Mr. Freeland, if you are unable to pay child support, you need to contact the front of the court. Don't sit on your hands. That creates more problems. It's like a sore that festers and becomes infected. You need to be proactive, Mr. Freeland. That's the message I want to leave with you today. You got to be proactive. If you get injured, you lose your job. And for example, you go back to Morris, won't hire you back. You need to notify the front of the court. Maybe you file a motion to reduce your support. Don't sit on your hands. And you need to you have not been paid child support. So, and if you're not paying child support, and there's a really good chance there's a bench went off your arrest, you need to make sure you keep contact with the front of the court so they know what's going on with you and you know what's going on.
Okay, I apologize.
No need to apologize. Just want you to pay attention to this obligation. It's not going away, and you need to reduce these arrearages. All right, so Mr. Laird, do you have any questions, Mr. Freeland?
No, Your Honor, I do not.
Ms. Hicks, do you have any questions for Mr. Freeland?
Questions?
Well, based upon the testimony of Mr. Freeland, the court finds a support order exist in these two files. Arrears exist in both files. Mr. Freeland acknowledges all of that. Mr. Freeland has failed to comply with an order making regular payments or remaining in contact with the front of the court. The lack of due diligence on the part of Mr. Freeland is a basis for contempt. Accordingly, this court finds Mr. Freeland to be in contempt of court on both of these two files before the court this morning. The court is inclined to follow the recommendation of Ms. Hicks with respect to jail. Mr. Later, I'd like to see if Mr. Freeland can post some type of bond. I'm willing to consider something less, but again, $500 total is not a whole lot. Anything further you want to say on behalf of Mr. Freeland, Mr. Later?
No, Your Honor, other than, of course, we do thank Ms. Hicks as well as the court.
All right, Mr. Freelon, how much can you post in terms of bond? I mean, zero is not going to do anything. So
I don't have no family. Like I said, I don't got no mom. I don't got no dad to support me. My wife barely, you know what I'm saying? Like I'm trying out here. Like I don't got nothing. I got $1 in my possession right now. Y'all can have $1.10. That's it.
okay,
My bank account in the negatives. Like, you know.
okay. You don't have any
I have nothing.
siblings, or your wife can't doesn't have the funds to post a bond on your behalf. Is that correct?
Correct. I have nobody but myself, and that's the truth.
Okay. Do you think you're gonna have the job with Tim Hortons when you get out?
I mean, maybe, I don't know. Y'all making me sit here 10 days. I mean, that's not gonna help. But I'm pretty sure if I got out, you know, I can probably make something happen. But 10 days, that's crazy. Like they just probably gonna what's the word I'm looking for? Eliminate me, if you want to say, or you know.
Well, you've been there for 15 years. Hopefully, you've been a reliable employee. They'll bring you back. And how many hours a week do you work at Tim Hortons, an average?
I'll probably work about like 31 hours a week.
Okay. Maybe you need to pick up maybe another part-time job. Ms. Hicks, how much did your office receive in terms of in the December and January income withholding or payments? Did it match current support?
These cases don't have current support obligations, Your Honor. When Mr. Freeland was incarcerated, it went down to 0, correct?
Okay. So I'm sorry, how much did you receive for the month of December and January?
So how much total?
So I can only look at one case at a time, Your Honor. Right now, I'm currently in the 2010 case. In January, we received $154.45. In December, $125.33. In November, $145.82.
Okay, and the court will assume that we received similar payments. Can you maybe look over the screen of the 2012 file?
Yes, I'm toggling over to that one now, and I can let you know. In that one, we received in January $234.58, in December $194.38, and in December, and then in November $226.58.
All right, at least I wouldn't describe them to be significant, but there's it's more than just $50. All right, based upon the fact that they come with holding order, Mr. Freeland, those
Your Honor,
are acceptable. Yes. Ms.
I
Hicks?
apologize. If the court is going to consider releasing him without posting anything, the friend of the court would like to make some additional elocution.
Okay,
Because
go ahead, Ms. Hicks.
those payments had been being received weekly, Your Honor, and they have stopped. The last payment was received on January 26th, and yet Mr. Freeland was not incarcerated until February 13th. He also has stated on the record now multiple times that he's been employed by this employer for 15 years. We've had other income withholding notices from different employers, the past year when those payments were coming in last year. They were not from Tim Hortons. So I'm not sure why he is or how he is possibly employed by this employer for 15 years when it's only been 3 months that we've ever received payments from this income withholding. And as I stated, they stopped in January, but had been coming in weekly. So I do believe he should have to post some amount of money as the friend of the court does not believe that this current employer is who he has been employed by for 15 years.
All right. That's a legitimate concern. Mr. Freeland, how come if they received the payment early in January, how come the front of the court has not received any payments in the last 30 days?
To be honest with you, see, me and my wife, we work at the same place. See, like, she's pregnant right now. You know, this is our 3rd daughter. Man, I just be like recently, I just been at home, sitting at home. I mean, I'll be honest with you. like my mother, she's a GM. So that's why I'm able to work here. I mean, I wasn't working here 15 years consecutively, but like through time, like I've been working here 15 years. That's what I meant. But she the GM, so like I can get like time off. You know what I'm saying? Like I take care of my kids. I take care of my kids physically. You know what I'm saying? I'm there for them physically. So I might have had to took some time off or whatever, and this and that. That's all it was. It wasn't that I wasn't just like not acknowledging the friend of the court. It was that I had to take care of other kids that I got to take care of. You know what I'm saying? 3 other ones. You know, on top of paying them and then on top of taking care of them. You know what I'm saying? It's a whole lot of stuff going on, and I don't get paid that much either. You feel what I'm saying? And then I'm trying to go to the Olympics. I'm trying to get at least a bronze, silver medal. You know what I'm saying? Bring it back to the U.S. Like I got a lot of stuff going on right now. You know what I'm saying? Like I'm trying to do something to take care of my kids, but this right here, this not helping me. You know?
Right, Mr. Freeland. But first of all, you might need to look for a better paid job. You can't afford to sit home. It's great that you're staying home with your 3 kids right now, but this court's only concerned about children born to you and Selena Smith and the children born to you and Caleb Buckley. That's the court. This court's concerned because you're not supporting those children. And when you can't afford to just take a couple weeks off to watch your other children, you need to. You need the income. You need to pay child support, and there's no reason why nothing was paid for the last 30 days. So the court's going to follow the recommendation of Ms. Hicks. That is, on each of these 2 files, sir, you are to serve 45 days in York County Jail as follows: 10 days immediately. You have a credit for the 4 days you have served. So that's 6 more days, but you can be released. These we serve together at the same time. You can be released this afternoon upon posting a $250 cash bond in each of these 2 files, total $500. And that's going to apply toward your marriages. So obviously, reach out to your mother and your wife. Maybe they can help you put that $500 together. It's 100% towards your marriage. It's not going to fines, costs, not going to attorney fees. There's no cost to you for Mr. Leiter. So reach out. You can be out home for dinner tonight if you can post at $500. So I'm cutting that bond in half. $250 on each case. $500. It can be posted in the evening at the jail over the weekend. Make some phone calls and at least and if in fact you don't have that job when you get back, then you need to file a motion. You need to let the front of the court know that. We're going to give you a date to come back for review. And this could be a Zoom review hearing, Mr. Freeland. Just keep in contact with the front of the court. You can avoid bench warrants, okay? And Ms. Hicks, what do you suggest for a review date?
April 9th at 10 a.m., Your Honor.
Okay, Mr. Freeland, you're to appear before Ms. Hicks April 9th at 10 a.m. via Zoom. There will be an order faxed over to the jail. One will be also mailed to your last address. Give you the Zoom ID number, April 9th at 10 a.m. So you don't need to come down to Monroe for that. Do you have any questions, Mr. Freeland?
No questions.
Okay. Again, it's 6 more days in jail. You can avoid those 6 days by posting a $250 cash bond in each of these 2 files, a total of $500. Thank you, Mr. Leiter, for your assistance.
Your Honor, thank you very much, sir.
All right, you can step up, Mr. Freeland. Ms. Hicks, thank you. Present.
Thank you, Your Honor.
I am. I'm just having a kind of hard time hearing you, sir.
Okay, I'll speak up and put the device close to your ear. We are, Miss Merrill's present, but she's got to turn on her audio. So just bear with us for just a minute, Mr. Merrill.
Okay.
I understand you're in the hospital, but I appreciate you being able to appear today.
I do everything I can, sir.
Hello?
Miss Merrill, can you hear the court?
Yes.
Okay, we've called the case. I've indicated that this matter is before the court for a pretrial conference. Same is being conducted via Zoom. Your husband, Paul, is present on audio, and you are present on the Polycom. Court's in receipt of a proposed consent judgment of divorce, which appears to be in order. Can both of you please raise your right hand to be sworn?
Yes.
Miss Merrill?
I'm sorry.
Yes, sir, I got it raised.
Miss Merrill, can you hear the court?
Yes, sir. Yes.
This is Melissa Merrill. Can you hear the court?
Oh, I'm sorry.
Melissa, if you hear the court, you need to raise your right hand to be sworn, please. Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Okay. We'll start with you, Miss Merrill. Can you please state your name and current address for the record? Miss Merrill, is it true that you filed a complaint for divorce with this court on about December 13th, 2023?
That's correct.
Is it further true that on the date you filed the complaint, you've been resident of Cudahy, Monroe for at least 10 days and state of Michigan at least 6 months?
Yes.
Yeah.
Is it further true that you married Paul Merrill on October 1, 2022, and you separated in May of 2023?
Yes.
That's correct.
These
Well,
questions are for
we
Melissa.
we
Paul,
kind of-
Mr. Merrill, just
I'm
a
sorry.
minute.
Sorry, I'm
Mr.
having it
Merrill,
all here, sir.
Mr. Merrill, do not interrupt,
Yes, sir.
please. These questions are for Melissa. I will then turn
Okay,
to you.
I'm sorry. I
So
didn't
please
realize
listen.
that.
Please listen. So that's true. You got about a 1-year marriage, Mrs. Merrill. Is that correct?
I'm sorry.
That is,
Melissa Merrill.
Oh.
These questions are for Melissa.
Okay, I'm going to shut up.
Okay, Melissa, is it true that the marriage is about 1-year marriage?
I'm sorry, that it's a what?
Put the device closer to lean closer to your device so you can hear. It's true it's about a 1-year marriage then, is that correct?
Oh, yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the opposite match would have been destroyed?
Yes.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Did you in fact sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Do you have any questions for the court?
I don't.
Mr. Merrill, can you please state your name and mailing address for the court?
173.
Thank you. Mr. Merrill, did you hear the testimony of your wife, Melissa, this afternoon?
Yeah, what you just asked me up.
Was her testimony true and accurate to the best of your knowledge?
The only thing that's not true is the fact that we separated on the 23rd of May because she called me a week later begging me to come over, and we've been dating the whole time until I got my that letter about my CWP.
Okay, the date of separation is not real critical for this court. The critical testimony.
That's fine. I just wanted to make you aware that she's lying.
The critical testimony, there's been a breakdown of the marriage, no chance of reconciliation. And Ms. Merrill testified there is not. Do you agree with that, correct?
Huh?
Do you agree with that, Mr. Merrill?
Yes, I do.
And you agree there were no children born or adopted during your marriage?
There were none.
Okay, and you signed your name to this proposed judgment approving the terms and conditions contained therein, is that correct?
Yeah, just whatever she wrote down, that she gets her stuff, I get my stuff.
You signed your name to this judgment. Mr. Merrill, just say, give me a yes or no answer. Did you sign your name to this proposed judgment?
Yes.
Okay, I'm going to walk through the terms with both of you. You indicated that spousal support is not awarded. It's forever barred. Each of you is awarded the personal property currently in your possession, free and clear of any claim part of the other. So you've already divided your personal property. There are no joint debts to be divided. Each will pay debts in their own names. Each will keep their own automobile and pay debt thereon. There's no real estate to be divided, and no pensions to be divided, or annuities or 401ks. Finally, Ms. Merrill is requesting restoration of her former name to that of Bustle. And it's also noted in the judgment that you each own your own home, and it's only in your respective names, so each will keep their own real estate.
Yep. Yes.
Okay. Do either of you have any questions?
No, is this the final judgment?
Yes. Based upon the testimony that's been presented this afternoon, as well as plain filed this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the opposite matrimony has been destroyed and there is no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved and judgment shall enter granting a divorce with bonds of matrimony. You are both now divorced. You both emailed a copy. And Ms. Boston, when you get your copy, you want to take a copy to the Secretary of State and Social Security to facilitate the legal change of her last name.
Yes. Thank you.
Okay, you can both zoom out. Have a good rest of the day. Good luck to both of you. You can hang up.
Court is now in session. Marie Hope versus Philip Hope.
The record of this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Court is in receipt of a proposed consent judgment of divorce, which appears to have approved by both parties. Marie, is it pronounced Hauk or Hoke?
Hauk. You said it correctly the first time.
All right, then Ms. Hoke, you are present. Is Philip Hoke present also?
Yes.
Okay. Good afternoon.
Good afternoon.
Everything appears to be in order. 33-year marriage. How long have you been separated, Ms. Hoke?
I moved out on May 15th.
Of 2023?
Correct.
Okay, thank you. Is it true, Ms. South, that you filed a complaint for divorce with this court on about November 16, 2023?
That is correct.
Is it further true that on the date you filed the complaint that you had resided in the county of Monroe at least 10 days and state of Michigan at least 6 months?
Yes, that is correct.
Is it further true that you married to Philip Houck on July 20th, 1990, and you separated in May of 2023?
That is correct.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any chance of reconciliation?
Not on my end, no.
Okay. So, of course, no fault divorce, but the court notes that this is a long-term marriage of 33 years.
That is correct.
But today, it's your testimony that there's no chance of reconciliation. Is that correct?
That is correct.
All right. Were there any children born or adopted during your marriage or are still minors?
No, no minors.
Are you currently pregnant?
No.
Okay. And you've signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
That is correct.
Thank you. Mr. Houck, can you please state your name and current address for the record? Thank you. Mr. Houck, did you hear the testimony this afternoon of your wife, Marie?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes, I did.
I'm going to walk through the terms of this judgment with both of you. You've agreed in this judgment that spousal support is not awarded, it's forever barred. Further provides that you've already divided your personal property, so each will keep the personal property currently in your possession, free and clear of any claim on the part of the other. There are no joint debts. Each will pay any debts in their own names. Each will keep their own automobile and pay any debt they're on. There's no real estate to be divided. And each will keep their own retirement plans or pensions or annuities or 401ks or IRAs. And Ms. Houck, you're going to keep the last name Houck. Is that correct?
That is correct.
All right. So Ms. Houck, do you have any questions for the court?
No, I do not.
Mr. Houck, do you have any questions for the court?
No.
Well, the court appreciates your cooperation in submitting this judgment, and it's wonderful that two of you were able to work together and resolve your own differences. Unfortunate, though, over a 33 marriage that will come to an end. But in any event, based upon the testimony that's been presented this afternoon, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter, granting a divorce from the bonds of matrimony. Judgment has been signed. You'll both be mailed a copy of this. Good luck to both of you. That will conclude this hearing. You can both zoom out and hang up and have a good rest of the day.
Thank you. You as well.
But you received a copy of the proposed judgment that Mr. Thornburg is asking the court to enter today. Is that correct?
Yes, sir.
Do you take issue or have any problems with any provision of this judgment?
No, I do not.
Okay. You've been separated for 14 years?
Yes.
Is there some reason why you would not sign the judgment?
I didn't even realize I had to sign it, to be honest with you.
All right, Mr. Thornburg, we've jumped through a lot of hoops to do this for you, Mr. Thornburg, because you have an attorney. It would have been a lot easier if you would have gotten Ms. Thornburg just to have her sign the judgment. Didn't you send her a copy?
Yeah.
Okay, I don't know why we're going through this default and having to send all these additional notices. It would have been a lot easier if you would just, we sent you the judgment, Mr. Thornburg, saying you need to fill it out, sign it, and then get the signature of the other side. So I'm not sure what the breakdown in communication was, but damn it, you're both here. All right, thank you. All right, and Mr. Thornburg, is it true that you filed a complaint for divorce with this court on November 17th, 2023?
Yes.
Is it further true that on the date you filed that complaint, you'd resided in the county of Monroe for at least 10 days and stayed in Michigan at least 6 months?
Yes.
Is it further true that you married to Diana Thornburg on August 11, 2007, and you separated in October 2010?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony that have been destroyed, there's no reasonable chance for reconciliation?
Yes.
Is it true that there are no children born or adopted during your marriage who are still minors?
Yes.
Is it true that you signed your name to this proposed judgment, approving the terms and conditions contained therein?
Yes.
Do you have any questions for the court?
No, sir.
Okay, Ms. Thornburg, can you please state your name and current mailing address for the court?
Diana.
East Helena, Montana.
Yes.
49. That mailing was returned to be undeliverable. Does it need to be Washington North Avenue or North Washington Avenue or
Stuff cannot be mailed physically to the house. We do not physically get mail here. I had to go to a PO box.
Okay, where do you want this mailed? Do you want post office box mailing?
Yes, please.
Okay, 35.
Yes.
Okay, I just want to make sure we're clear. Ms. Thornburg, did you hear the testimony of your husband Brad this afternoon?
Yes, I did.
Was this testimony true and accurate to the best of your knowledge?
Yes, it was.
Are you currently pregnant?
No.
Okay, this judgment of divorce, and with your approval, Ms. Thornburg, I will indicate that you've approved this via Zoom, even though your signature will not appear in there. I'll put my initials by that if that's agreeable.
Okay.
I'm sorry?
I said okay.
Okay. All right. This judgment provides that spousal support is not awarded to either party. It's forever barred. Each party shall be awarded the personal property currently in their respective possession, free and clear of any claim on the part of the other. There are no joint debts to be divided, so each will pay debts of their own name. Each will keep their own automobiles, keep any debt thereon. There's no real estate to be divided. There are no pensions, annuities, IRAs, or other retirement plans to be divided. Ms. Thornburg, do you want to keep the name Thornburg, or do you want your former name restored?
I'm fine either way, honestly.
Okay, well, I'm going to leave it Thornburg unless you tell me otherwise.
That's fine. I'd rather not go through the hassle of going through Secretary of State and stuff. So.
Okay, all right. All right, do you have any questions for the court?
No, I do not.
All right. Well, thank you for appearing. Even though you didn't get this notice, obviously you've been in contact with Mr. Thornburg. Earl, based upon the testimony that's been presented this afternoon, as well as plain evidence, following this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, the judgment shall enter granting a divorce from bonds of matrimony. The court assigned the judgment, a copy will be mailed to each of you. That concludes. You can both zoom out. Have a good rest of the day and weekend.
You too.
Thank you. Ms. Walker, is it true that you filed a complaint for divorce with this court on about November 27th, 2023?
Yes.
Is it further true than the date you filed the complaint that you reside in the country of Monroe at least 10 days, state of Michigan at least 6 months?
Yes, that's true.
Is it further true that you married Austin Walker on December 29th, 2002, and you separated in November of 2023?
Yes, that's also correct.
Is it true there's been a breakdown in your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage who are still minors?
No.
Are you currently pregnant?
No.
You signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Yes.
All right. To Ms. Walker, can you please state your name and current mailing address?
Your Honor, I'd wish not to put my mailing address out there. I've had problems with Miss Walker calling me and trying to show up places, and I would request that I not give my address out. Or if I could
state your name.
That's fine. That's
Austin
fine.
Walker.
I don't need to know it.
Please state your name.
Austin Ryan Walker.
Okay, Ms. Walker, we have two different. We need to mail it somewhere. We've got two different addresses.
That is fine. You can send it to Oak Haven. I can receive mail there.
Okay, which address? Thank you. Mr. Walker,
Yes,
did
sir.
you hear the testimony this afternoon of your wife, Kylie?
Yes, I
Is
did.
her testimony true and accurate to the best of your knowledge?
Yes, Your Honor, there is no reconciliation of this marriage whatsoever.
Did you sign your name to this proposed judgment proving the terms and conditions contained therein?
Yes, sir, I did.
All right. I'm going to walk through the terms of judgment with both of you. And you agree that spousal support is not awarded. It's forever barred. You've already divided your personal property, so each keep the personal property currently in your respective possession. There are no joint debts to be divided. Each will pay any debts in their own names. You keep your own automobiles. There's no real estate to be divided. No pensions or 401ks or IRAs to be divided. And finally, Ms. Walker is requesting restoration of former name to that of Bogoski.
Yes, Pagowski.
Ms. Walker, do you have any questions for the court? Ms. Walker, do you have any questions for the court?
No, Your Honor.
Mr. Walker, Austin Walker, do you have any questions for the court?
No, I do not, Your Honor. Well, actually, I do. About how long will it take for the divorce to be finalized?
Today, right now.
Today? Oh, beautiful. Thank you. I have no more questions.
Both go out and celebrate tonight. And Ms.
Yes.
Ms. Bogowski, when you see this judgment, you need to take a copy to the Secretary of State and Social Security to facilitate the legal change of your last name, okay?
Yep, I know how to do that. Thank you so much.
All right, based upon the testimony that's been presented this afternoon, as well as plain follows matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There was no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce in bonds of matrimony. Good luck to both of you. Mr. Walker, keep in mind you got to pay that $175 before March 29th. Okay, so get that taken care of when you get back.
Oh, yeah, Your Honor. I'm about to go out and be well worth it. I'll take care of it as soon as I get back in 2 days.
Okay. All right. That concludes this matter. You can both zoom out. Have a good rest of the day. For the record, this matter is before the court on plaintiff's objections as well as defense objections to a referee recommended order of December 13th, 2023. And the parties have engaged in mediation with Ms. LaPrade for the front of the court this afternoon. This hearing is being conducted via Zoom. President's Attorney Christina Hills representing the plaintiff, Mother Josephine Summers. Ms. Summers is present. In addition, Attorney Catherine Kajewski is present representing the defendant, Father Daryl Summers, and Mr. Summers is present. And good afternoon, everyone.
Good afternoon, Your Honor.
I heard Ms. LaPrade referencing a date for review, so I will share with you her recommendation. The recommendation of Ms. LaPrade is that the referee recommend order be rescinded and canceled. And that the parenting time should be as follows. Week 1, follow shall have parenting time Thursdays at 6 p.m. until Monday, following Monday, 7:30 a.m. Meeting at the Monroe County Sheriff's Office on Thursday, 6 p.m. And then, at school on Monday morning during the school year. Further, the parties will review the issue of parenting time on May 7th, 2024, 1:30 p.m. With respect to holidays, the front of the court holiday schedule shall be adopted. The parties shall have 1 week of uninterrupted.
Should say parenting time.
Summer parenting time with 30 days notice. No third-party discipline of the children. A third party may transport, if known to the children with a valid license, not under the influence of drugs or alcohol. The party shall use AppClose for all communication and the calendar for all appointments for the children when scheduled. All communication shall be civil and respectful and regarding the minor children only. The minor child court will continue counseling on Zoom. The child will be at the library. And neither party shall be involved unless the therapist requests the presence of a parent or both parents. This order would resolve all parenting time complaints as of today. Step parents are not to be on anything other than the emergency contacts. Step parents are not to be on anything other than emergency contacts on medical records. Father will have a make-up parenting time March 15th through the 17th, 2024 by agreement of the parties. The issue of child support shall be referred to the front of the court for formal investigation recommendation, with each party having 21 days which to object to the recommendation. However, the effective date of any support order will be March 1st, 2024. That is the recommendation. Ms. Sills, is this recommendation agreeable with your client this afternoon?
Your Honor, if you indicated I missed it with regard to the adoption of the front of the court holiday schedule, absent an agreement in writing. And I don't know if I heard the court read week 2 of Dad's parenting time.
Oh, yep, that would be correct, because I started typing and we kept talking. So, Your Honor, week 2 visitation for father is Wednesday, 6 p.m. to Friday at school.
And the recommendation does say that the front of the court holiday schedule is adopted, and the parties shall have 1 week uninterrupted parenting time with 30-day notice to the other. So obviously, if the parties, I think it's implied, Ms. Sills, that if the parties agree otherwise, they should, about holiday parenting time, they should reduce that to writing.
Yes, thank you. With those clarifications, my client does in fact agree to this recommendation.
Thank you. Ms. Sills, Ms. Kajewski, is this recommendation agreeable with your client this afternoon?
Yes, my client and I agree with this recommendation.
Wonderful, thank you. Right, Ms. Sills, do you want to begin with Ms. Josephine, please?
Yes, Ms. Summers, would you state your name for the record, please?
Josephine Summers.
And have you heard the recommendation read by the court this afternoon and clarified by me after that?
Yes.
And do you understand all of the terms of that recommendation and agreement?
Yes, ma'am.
Do you have any questions about it as you sit there right now?
No, ma'am.
Have you had enough time to think about all of these issues?
Yes.
We arrived at this agreement through mediation this afternoon with Ms. LaPrade, is that correct?
Yes, ma'am.
And you were an active participant in that mediation?
Yes, ma'am.
Do you believe that these provisions at this time, knowing of course that there's a review in May, but at this time, do you believe these provisions are in your children's best interest?
Yes.
And are you satisfied with my services on your behalf?
Yes, ma'am.
Thank you. I have no further questions.
Thank you, Ms. Sills. Ms. Kajewski, do you first of all have any questions for Ms. Summers?
Not for Ms. Summers, no.
Okay, voir dire of Mr. Caswell, please.
Sure. Mr. Caswell, did you hear the referee recommendation proposed order that was read onto the record?
Yes.
And do you agree with the terms of that proposed order?
Yes.
Do you find it to be fair, equitable, and in the best interest of your children?
Yes, I do.
And you wish to withdraw your objection and enter this order in lieu of that?
No, I do not want to. Wait. I
Sorry,
don't.
maybe I'm asking the question wrong. Does this resolve the issues of the objection?
Yes, it does.
Okay, thank you. I have no further questions for my client.
Thank you, Ms. Kajewski. Ms. Hills, do you have any questions of Mr. Caswell?
No, Your Honor. Thank you.
And just to make sure the court's understanding, the parties pursuant to the judgment of divorce, August of 2021, the parties shall have joint legal, and they'll continue to have joint legal custody, but
Yes, Your
physical
Honor.
custody is to the plaintiff mother. Is that correct?
That's not been modified as of the agreement today. However, our position is that the parenting time arrangement really controls anyway.
Sure, the court agree. I just noticed that there must be a typo in the judgment, Ms. Hills, because the judgment, if I'm not mistaken, says physical custody awarded to the defendant.
Oh, that's entirely possible, Your Honor.
Okay.
I can certainly clarify that
Okay.
if need be, or just simply reiterate joint legal custody well, we're not doing a court order.
Nope. There's no need to. I just make
Okay.
it as an observation. I think there was a typo in the judgment of divorce, but obviously everyone's on the same page. And as you know, this court, obviously the parties should not to have a co-parent and make decisions regarding the major decisions during the welfare of their children, having joint legal. And this is all about parenting time. That's what's primary at issue here is the parenting time.
Great, and I'm certain that's not the only mistake I've ever made. So thank you for
No,
letting
I
me
just
know
want
that.
to make sure that I understand, because I always like to know where things stand. So, thank you, Mr. Pratt, for your time and effort this afternoon. You're going to add just a sentence in here.
Yes, sir,
about
I did.
week
I
2.
corrected it. It is in your queue.
Yes. So week 1 will be Thursday at 6 p.m. until Monday, 7:30 a.m. for dad. And week 2, Wednesday, 6 p.m. until Friday, 7:30 p.m. And when will this start? When will dad's start his week 1 or week 2? Are the children with dad right now?
And Mr. Caswell, whose weekend is this normally? This weekend that's coming up that would start today normally?
This is Josephine's.
Okay.
So that means he would have the following weekend.
He would have the following weekend.
Starting
so
on Thursday.
Next week will be week 1. Yeah.
Okay. So dad's week 1 would commence on Thursday, which would be the 22nd of February. 6
I thought I
p.m.
heard
at the
that-
Pinellas County.
Right, I'm sorry.
Go ahead.
I thought I heard the court say 7:30 PM, but it would be AM, so.
That
Yeah,
was
six-
another
six-
LaPrade typo, Your Honor, so I'm trying to fix it.
See, I'm
No,
not the only one.
okay,
Should say 7:30 AM, Your Honor. There should be an updated recommendation yet again coming into your queue.
6 PM until 7:30 AM.
Correct, Your Honor.
All right, again, thank you, Mr. Pratt, for your time and wonderful fine assistance. And the court would also like to thank and acknowledge Ms. Sills and Ms. Kajewski for helping facilitate ample resolution. The court would applaud mom and dad. Without question, the two of you know what's best for your respective schedules and that of your children. Please work together, communicate for their best interests. There's enough challenges in life. Make it good for each other and the children.
There's my client.
Looks like we
lost my
lost Miss
client.
Josephine.
I can certainly fill her in on the court's words and that the week 2 was added. I'm not sure when she dropped.
Okay,
But,
it's all in there. All right, the court will adopt the recommendation. To thank you all again. You can now zoom out. Have a great rest of the day and weekend. Thank you again, Mr. Pratt.
Thank you
Your
very
Honor,
much.
have a
Your Honor.
good
You too,
weekend.
and thanks,
Thank
Mr.
you.
Pratt. Thanks, Miss. She's gone too. Right. Bye-bye.
Bye.